and welcome back to Fossil versus Future. I'm Daisy.
And I'm James.
And today we're going to talk about
the responsibility of states for climate change.
For our What About Law episode a while ago, we spoke with Philippe Sands about the International Court of Justice's advisory opinion on the legality of the threat or use of nuclear weapons. Published in 1996, that opinion was significant for many reasons, including its recognition of a state's obligation to protect the global environment. Philippe mentioned that an ICJ advisory opinion on climate change was on the horizon. Well, the time has come. Last week, the International Court of Justice, or the ICJ, the world's highest court, delivered its long-awaited advisory opinion on the obligations of states in respect of climate change. This landmark opinion confirmed that states have a legal obligation to protect the environment from greenhouse gas emissions and must act with due diligence and cooperation to fulfill this obligation. This includes the obligation under the Paris Agreement to limit global warming to 1.5 degrees C above pre-industrial levels. So we wanted to dedicate this episode of our Intergenerational Climate podcast to this moment for two key reasons. First, from everything that I've read and seen online, this seems like a really big deal. But it seems the implications are still unfolding. Intergenerational dialogue is all about learning. And so I want to learn from you, James, as an expert in international environmental law. What does this opinion actually mean? And should we really be excited about this? And second, the origins of this case are inspiring and worth celebrating. In 2019, a group of 27 law students from the Pacific formed an organization called Pacific Island Students Fighting Climate Change and launched a campaign for an advisory opinion on climate obligations. Their efforts were taken up by the government of Vanuatu, and in March 2023, the UN General Assembly adopted a resolution formally requesting the ICJ's opinion. UN Secretary-General has called the outcome a victory for our planet, for climate justice, and the power of young people to make a difference.
So there's lots here, Daisy.
Yes, there is.
And we need to go through as much as we can, partly to counter some pretty poor reporting that has gone on so far, and we'll come back to the sort of oft-repeated non-binding phrase.
Yeah.
Partly because, as you say, the action was brought by youth via the agencies of the UN system, which include the ability to ask the International Court for an advisory opinion, which is really a declaration on what the law is. Partly also, yes, long personal history. It's particularly pleasing to me to have Vanuatu be behind this case in some large part, because, as you will recall, I represented Vanuatu, and when we formed the Alliance of Small Island States, that was the country whose delegation I sat on. But even before that, the legal opinion that I wrote for Greenpeace all those years ago, which was my introduction to the subject of climate change and the connection with international law, if you recall, what I advised them, and then I wrote in that law review article with Durward Zelke, that actually came out in 1990, but we wrote it a good 18 months before that, made the case for an international treaty on climate change, as opposed to taking a case to the International Court of Justice. Now, just as a reminder, why did we do that? Why did I make that argument to advise Greenpeace all those years ago not to go down the ICJ route? Because they wanted to bring a case, probably from one of the Pacific Island countries, against the United States of America. So in a direct action against a party responsible, a state responsible.
Yeah.
And I argued that the US would never submit to the jurisdiction of the International Court, that there were many other countries who had some responsibility for the climate change problem, and that a better way of using legal arguments on state responsibility would be to negotiate a treaty. Not that they were either, not that you could not do the ICJ route, but this particular way of doing it would probably be unsuccessful and less useful at using the law to solve the problem. Okay, so all these years later, we have come to the International Court, but not in a direct action against the US, but through this route, which engages a political process, the General Assembly, and therefore allows countries to decide for themselves whether they want the International Court to make this ruling. And then you have a legal process, not a political process, a legal process where evidence is reviewed and legal arguments are made for and against. Some of the countries that participated in the ICJ did not make arguments against the science, but made arguments that were kind of equivocal about using the court in this way, and really we should give the treaty system that's a full authority to deal with this problem and not have other legal arguments floating around. And there was a lot of the arguments were not directly resisting the thrust of the science or the availability of legal process. It just, in their view, didn't involve using the ICJ in this way. Well, ultimately, the court made a declaration of law. That they took in the evidence, they considered it, it was properly contested like in any other court. Many countries participated. I probably should know exactly how many, but many participated. Lots of other inputs to the process from organizations that have some responsibility for legal arguments. The net result is you have a judgment from the ICJ about what the law is. And an advisory opinion does just that. There are equivalents in other legal systems. So you can go before a court here in England and ask for a declaration of law. That is a remedy that you can seek by going to a court.
Some clarity on what the law is.
Yes, exactly. And so this is a case where it's not a dispute between two parties where the judgment binds one, where one party wins against another. Right? That's not what advisory opinions are, and that's not what's happened here. It's perfectly pointless making the argument over and over again, and like every single journalist seems to be doing, that this is non-binding. Of course it's non-binding in that sense, because it's not a case against a particular party. The language is not complicated to understand. Ordinary English is all you need to understand what's happening here. And if you read the ordinary English, it's quite a well set out judgment. It's quite useful just to see the video online. It's a declaration of what the law is. And the law is binding. Right? That's the law. Okay, it might change. There might be a case next year, or there might be a reinterpretation of the law. There's all sorts of ways you can respond to that. An individual state may say, well, you may think that's the law, but we're going to legislate in a different direction. One can imagine that happening. But it is a completely useless observation to simply assert that it is non-binding. We'll get to some of the detail in the judgment, right, because it's really very interesting for someone who has been in this story for a long time, just to see things like the elevation of human rights into the conversation. That really wasn't so prominent when I first started working on it. It's grown over time, the relevance of human rights discourse and obligations. And that's quite interesting from an intergenerational point of view. It's also interesting that the court has done what I really did hope would be the case years ago when advising on this, which is to say there is a treaty process, and it has taken a very long time, but it's arrived at a certain point where there is legal text that we can interpret, and they've done that. And that's why they've emphasized the obligations in the Paris Agreement. So that's contractual. That binds the parties to that particular treaty. But they've gone further than that, and they said that because of all of these actions over the years, both in treaty form and in other forms of non-binding political declarations and other actions taken at the national level, and many, many, many instances of courts and tribunals ruling upon a particular aspect of climate change and the law, the court has said this is part of customary international law. And customary international law, when a court makes that determination, that's highly significant because that binds everybody, whether they are part of a treaty or not. So the observation that ought to be obvious to anyone seriously reading and understanding this judgment is not that it's non-binding, but that it is binding upon the whole of the international community, on all states, not just those who've signed a particular treaty and ratified it. All right, well, we'll get to other consequences in due course, but the first and most obvious is this will be drawn down into many other decisions. International tribunals, of course, will look to other areas of international law and make use of them when they're making decisions, and there isn't a higher source than the ICJ. So if there's a case before the Law of the Sea Tribunal or some other international arbitration or the kinds of things that international lawyers work on every day in various ways around the world, they will have reference to this advisory opinion. Secondly, regional courts, like regional human rights courts, for example, will have reference to it. Now there's a ruling that they can apply. They can say, this is a case that sets out the law, and we can apply it to the particular circumstances of this case, which might be against an individual state, for example, for failure to do something. But perhaps the most important from the point of view of the raft of decision-making that happens every day in boardrooms and in local government, or a whole series of decisions that are made in the context of the law, is that domestic tribunals will now have a reference to international law that they can apply. Now, that will vary country to country, depending on how the constitutions of those countries draws down international law into their domestic law. And it is quite, some countries are really very different from each other. Some countries apply international law directly. So their constitution says once an international agreement has been made or an international court has ruled on something, that is automatically part of our law. We don't do that. We need some sort of translation of the international into the domestic, either by statute or by one of our courts applying it in that way to our domestic law. It would be very interesting, I think, to take this judgment to judges in a place, maybe in an academic setting or somewhere where they can freely discuss this issue to figure out how they might apply it, given the particular sets of facts, or a government that was acting contrary to it. What would they do? Here in this country, it would probably be part of our administrative or public law. You'd use judicial review if a government, no matter what type of government or what type of politics behind the government, if a government decided to act in a way that was contrary to the very clear statements of the law in this case, what would be the remedy? How would a domestic court, an English court, say, apply international law to a decision made by our government in the face of the ruling that we've just had?
So if our current government or a future government decided to roll back on our net zero strategy, for example, that could have consequences linked to...
Absolutely. The English courts have been, I would say, patchy in their understanding of and application of international law. It ebbs and flows. There are times when there's, real clarity about the relevance and the what we call the justiciability. I mean, the ability to take an international law principle or a rule and apply it directly to a set of facts in an English court. Very often international law is couched in more general terms or requires some further act of legislation to make it specific enough to apply in a domestic court. And the English courts, on the whole, favour They want to see something that is a bit more specifically detailed in its application to the issue before them. They're easily frustrated by things that are too general. But it depends. We've had cases here where the English courts have found it relatively easy to match, if you like, an international legal principle with a domestic one. It always helps if there's a very clear alignment between international law and a well-established principle of English law. Then they feel more comfortable applying it. This judgment sets out quite clearly the categories of obligation. Obligation, let me just underline it again, right? Non-binding, nothing to do with it. It's an obligation. There's nothing confusing about the word. That is an obligation on the state, right? It's state responsibility. It doesn't matter what party is in power at any one time. So yes, there could be a situation where there is a change of government and we get these sovereignty arguments emerging, and you have a government in this country or another saying, well, we just don't care what an international tribunal says. Lord knows we've heard that phrase before. Right? And that's where I felt, when we had Philippe on the program, he used a really good phrase I've thought about since, and I think it's very relevant to this conversation. And he said, international law is a long game. Well, this might have been a long time coming, this judgment, at least in my working life. But its application, the effect of it, will also take time and will be tested, and it will not always be applied. There will be a reaction against it. There will be a populist reaction against it. There will be people who say, who cares? And we are in a time where that sort of might is right rhetoric is prominent. And I would just suggest that, and again, for all those who are writing about it or putting stuff on social media or running programs on radio and TV, next time you use the phrase non-binding, ask yourself, what is it you're trying to say? Right? Apart from not being able to read the text very well, my sense is that there's quite a lot of acceptance of the idea that what really matters is politics. What really matters is force, power in its most obvious sense. This is a really good moment to say, no, actually the law really matters. And it really matters even in the face of those who say it doesn't, because it's a long game. And there will be a time where there will be accountability, there will be a reckoning, there will be a generation who will say, no, we paid attention all the way along, and now's the time for there to be accountability in law.
So what about the major emitters that are likely to, the US, for example, currently is presumably not going to pay much attention to this advisory opinion?
No, it's pretty obvious that not only not pay attention, it'll be dismissed as irrelevant, and there'll be lots of rhetorical language used, and it will be actually probably a bit of a rallying cry for the supporters of America First. It's not exactly it won't be a surprise to have that reaction, and they are withdrawing from pretty much all international institutions. It's almost a systematic withdrawal. It's not random. They are asserting that there is really no role for these international institutions, and they've already gone too far and not in their own interests. One of the great ironies of these nationalistic movements is that they ultimately defeat themselves. They cause themselves pain. It provides a burst of energetic power for a period of time. It tends to burn out and cause a lot of damage and loss of life, usually. And then there's a correction, often after conflict, war. There's something that has to be reset after this nationalistic urge has been satisfied. So yes, of course, this particular administration will not pay it much mind.
And does it matter if they don't?
Well, as I said, it's a long game, and the statement of the law is the statement of the law. I mean, there could be further cases that modify it or change the direction. That's quite possible. But, it's pretty authoritative. I don't imagine much will change in, say, the next 5 or 10 years. I would say in most instances where the assertion of might is right, power politics has fully played out, and as I said, often that involves some form of serious conflict. In the settlement afterwards, there is some kind of accountability. It's also true that the United States of America is a more complicated and interesting place than one version of the federal government in one period of time. So there will be other parts of the US state that does take the rule of law seriously and is interested in what an international court has to say, and will perhaps do its best in difficult circumstances to apply the ruling. There will be hundreds of cases, including in the States, applying this ruling, connecting it to their own domestic legal system, connecting it to the Constitution. I would imagine that the intergenerational element will feature regularly in the States. There have already been cases. Not all of them have been successful, but as we said in a previous episode, that may not matter. And the election cycle comes around, and the people of America will have their say as to what it is they want to see in terms of political leadership. And I think that for a decent chunk of the population, a ruling like this would be relevant and helpful to the case they want to make, the political case they want to make. But before you get to that, I'm interested in how courts and tribunals, including domestic tribunals, would take this and apply it to situations that make a difference, material difference to parties in a particular case. It might be to do with something like insurance or an arbitration where international law is engaged in some way. It might be a dispute over investment in another jurisdiction, and there will be consequences. They'll ripple through. But yes, the top line point will be this particular administration, the States, will not take seriously this judgment.
Do you think it will encourage companies to continue acting on climate change? Because we're seeing lots of companies, well, maybe just green hushing
Yes.
and not speaking about their sustainability strategies. Do you think it will make them think, oh, hang on, maybe we do need to step up our action on climate change, start working towards these climate targets? And
So we talked about this in more than one episode, but I'm thinking about the one with Clover,
yeah,
where we wanted to understand, what cuts through, what gets through to a board or a decision maker in the corporate world. Where does the "I must do something about this" happen in the minds of decision makers? The obvious way is when there's an obligation that's nice and clear on them directly, on the company. You need to do a bit of work to make the connection between the obligations here and the obligation in the boardroom.
yeah,
Right? There's a gap because these obligations are on the state.
yeah.
Okay. What the state does in response to this that will ultimately affect what the CEO or the board does in the company. But the language, I would like to think this could be, there's should possibly some wishful thinking in this. I would like to think that any serious decision maker on a board that reads even the summary of this case would have cause to think very carefully about how they exercise their decisions that would help to concentrate the mind on the summary of the science, the explanation of the legal obligation, the particular reference to human rights and to generations who are most affected having their, if you like, future rights affected by the failure to act on climate change. If they just read it, or the summary of it, thoroughly, paying attention, I'd like to think that would resonate. And then, yes, there might be a specific requirement. But it's more to do with, as Philippe said in the episode, it's more to do with change of consciousness or having your consciousness affected by the way this was reasoned. Yeah, I think that's probably it. Until such time as a state does something specific to implement. Or possibly there is a legal case. Take some element of it. And it happens in that company's jurisdiction. It might be picked up by their general counsel. So there's been this case in our jurisdiction. It's come to this decision. We need to apply it. Or a conversation comes up with their insurers. So what am I saying? I'm saying that there's a gap between this ruling and anything specific enough to require a board to decide in a different way. But in that space, there is scope for reading and understanding the decision in a way that might alter your perception of what you should be doing with the decision-making power that you've got on a board.
And so if it is an obligation at the state level, are states now obliged to set regulations on companies to limit their emissions?
Yes, that's what it says. Now, it doesn't tell you exactly how. That would be an overreach, right? It's saying that to comply with your international legal obligations, you, the state, have to do what you can in a form that you choose, that your political economy can bear. I mean, there's all sorts of scope for difference in that. But you must use your powers, your sovereign powers, to act in accordance with the law because this is your duty. And the other duties that they emphasize there, which I think are, again, perfectly clear and perfectly rational. You see the language that of the duty to cooperate. Right? Well, there's plenty of scope for deciding how you do that, and indeed with whom. But given the nature of the problem, given the way the science and the evidence was analysed, the way to make sense of your legal obligation is to say that in these circumstances, you, the state, have a duty to cooperate with others to fix the problem. That's common sense. You know, the other duties in there are to do with, really, I get to put it in common parlance, taking the issue seriously, doing thorough due diligence on what you can and can't do, bringing forward legislation that's consistent with your own particular circumstances. Obviously, not every country in the world can do the same, have the same response, has the same capacity to solve the problem. Loads of scope for variety of response, but not anything that detracts from the overarching obligation to do whatever you can to fix the problem.
So something like subsidizing fossil fuels, that might be
It's clearly mentioned.
Oh, is it?
Yes, specifically mentioned as an example. The absurdity of just how much is spent literally fueling the problem. I mean, it's remarkable. I mean, I can't help, I'm trying not to recall the Trump monologue on windmills.
Oh, gosh.
Which we just had. It is remarkable how the idea that renewable energy is dependent on subsidies has somehow stuck when in almost every jurisdiction now they are not. Whereas the continuing subsidization of so many elements of the fossil fuel industry and its usage is somehow has escaped, if not notice, certainly opprobrium or whatever it is that would stop it. So it's just remarkable. And I think it does speak to a dependency that is we've talked about before, is understandable. People just go about their daily business, can't quite imagine a life without these incredibly valuable substances called fossil fuels. We just haven't yet got past it. And we will. We will. So looking at the future rather than the fossil. We will. And it is only a question of when. But we might have to have, a period of time where we have just very, very different worlds. A world that's electrifying, a world that's hanging on fiercely to fossil fuels.
So I think maybe one of the reasons that this non-binding term is used is a lack of understanding of international law and how you actually enforce international law.
Yeah.
So how do you police it? Human rights, I guess, is a good example.
Yeah.
You constantly hear about countries breaching
Yeah.
human rights law. How do you actually police a state?
Yeah, yeah.
It's not like you can take a state to prison or something like you would at the...
No, this is an age-old problem for international law. And it's worth remembering, thinking of the long game phrase.
Yeah.
It was also the case with domestic law a long time ago. The idea that there would be a single law binding all of England and Wales, or previously Scotland and Ireland, it was a very remarkable idea a long time ago. And the United States of America is a federation of states, and it was always intended that there be a state law and federal law. In a way, federal law is the international law of the United States of America, right? So it's actually not. There's loads of historical examples of how legal systems expand, contract, extend. The law of the Roman Empire was international law. There's just countless examples of how law extends and reaches. And yes, it is always dependent upon some kind of power to enforce. And international law has many limitations when it comes to enforcement. And mostly enforcement of international law comes via mutual interest. So, and this is one of the things that it's worth reminding nationalists about. If you repeatedly declare the irrelevance of law, there comes a point when you might be wanting to rely upon it, and someone else is going to say, well, you don't really care very much about law, so you can't rely upon it in this circumstance. Right? Reciprocity, mutual obligation, the reason why international law is actually mostly complied with is because it's in the interest of states to do that, and because they've gone through elaborate processes to figure out whether they want to be bound at all. So the flip side, all that agonizing over whether or not there's consensus to agree this, that, and the other, and over every subordinate clause, which drives people in and out of the system mad. The point of that is that when you finally arrive somewhere, you've agreed what you can agree and can apply. All right, so that's mostly what happens. So mostly international law is adhered to for those reasons. When there are conflicts and disputes, there are international courts and tribunals to try them. And they are mostly complied with for the same reasons. And then you get to the areas that are more difficult to both argue for and recognize as being part of enforcement, but are, which is use of force. The international legal system does sanction and apply force in order to comply with the law, and the Security Council makes those decisions. And that's really where real-world political and military power combine with legal power. And there's a mixed record of the use of that force, as there is in all areas of conflict where the law is both applied and disapplied, sometimes all in the same conflict. But the other thing that is perhaps most relevant, and to this case, is that international law often has its effectiveness determined by national legal systems. It's by how a domestic court draws down international law into something that they can apply to a specific set of facts. And that's why we use these phrases like justiciability and enforceability and the things that are really to do with, can I take this obligation agreed over here and apply it to this circumstance in my court or tribunal where these parties have a dispute and these are the facts? And the answer is sometimes yes, sometimes no. And it depends is the only the sentence. But that is the way the vast majority of international agreements end up being applied to ordinary citizens and companies and to decision makers, whether they be in government or in the private sector. And that's what will happen here over years.
Yeah.
Not directly tomorrow. And there will be recalcitrant states. There will be people who just won't bother. But there will be consequences. That's why the rule of law really, really matters. Whoever you are, however powerful you are, eventually there are consequences from ignoring it. And they affect you in other ways. If you put out the notion that I don't care, there'll be an instance where you do care. And someone else will be able to say, well, why should I comply with the obligation you want to make? To which a lot of the sort of more aggressive form of nationalists say, well, in which case, I've got the force, I'll compel you. That's my enforcement, all right? So then every commentator, every populist politician who wants to make those arguments has got to be able to say, with a straight face, I'm in favor of force without the rule of law. Fine. Now we know what you are.
And in terms of individuals and leaders that might come out and say something like that, there's a difference between the International Criminal Court
Yes.
and the International Court
Yep.
of Justice.
Yeah.
What's the difference?
They're different tribunals.
Okay, so one is for states and one is...
No, they're both institutions that are set up by states. But the International Criminal Court is a place where you can have an international trial of an individual.
It's for individuals.
And so when you've had a political leader that has been responsible, or that was the allegation, and will be tried, but the court will rule upon whether there is sufficient evidence that that individual has committed an international crime, crimes against humanity or something of that nature. And they are tried as an individual, yeah. Regardless of whether they've been a head of state or a senior politician or the general in an army or whatever it is.
And so this advisory opinion, will link to ecocide and the work that's being done around
It's a good question, that. Ecocide obviously has its own pathway, and we've talked about it being relevant, again, to whether individual countries decide to make it a crime. I would say that this ruling is quite helpful for the ecocide movement, if you like, because of the way it assesses the evidence and comes up with a very clear statement of legal obligation in respect of climate change. But ecocide is a particular version, almost a subset of the ruling.
Okay.
It would be quite interesting to see how it feeds off the judgment. I can imagine there'll be some people say, well, perhaps we don't need ecocide now. We've got this. And others say, no, we need it more because this is a specific crime we want to focus on, as opposed to a general obligation on the state.
Okay.
So you can see how the arguments might line up for and against pursuing the ecocide route in the face of this. But you're right to emphasize that ecocide is about a crime, and it's equivalent to or sits alongside genocide as a crime, as opposed to a general obligation on the state to do whatever they can to mitigate climate change. And the other thing we haven't really emphasized, but is there in the judgment, is there's a whole series of equivalent obligations on adaptation. Because what the court is saying is, look, now that we know about the evidence, then you, the state, knows that you've got to do whatever you can to mitigate, but also to adapt. So you have an obligation not to expose your citizens, your population, to the risks of climate change. So you can't ignore the physical consequences of climate change that are already committed to. You've got to do something about that too. That's interesting and quite pragmatic, because it's saying, look, when you go through the sum of all your legal obligations, obviously prevention is vital.
Yeah.
But now that we know what's coming, it's not the only obligation or the only form of obligation you have. You've got an obligation to the people whose sovereignty you represent to act in a way that causes them to have less risk from climate change.
Exciting.
I know it's just one of those moments where lots of arguments come together in a form that could be a genuine shift in the way people think. What's, I think, striking about this moment is it comes at the very same time that there's a political shift in the opposite direction. So you really are seeing consciousness collide, ways of thinking about the world clashing. Now, I take probably an optimism bias. I take the view that is exciting, because that's when things get rethought, where creativity emerges, when there's a real clash of ideas. In times of risk and conflict and turbulence, those are times of maximum creativity. So I really do think, in the worlds that I've operated in all over these many years, this is an exciting moment. This will be a moment of rethinking and recreation.
I hope so. Thank you so much for listening to Fossil vs. Future. If you enjoyed this episode, please subscribe and give us a rating. Follow us on social media and send us your what about questions that you'd like us to discuss.